Case is actually a serious case compared to the last couple. And this is a case where a mouse, you see that's not the actual mouse there, though that guy is pretty adorable. A mouse had been engineered by researchers to be susceptible to getting cancer. And this might sound just very nasty to do, but you can see there's actual applications to it, right? Because if you make a mouse that's very susceptible to getting cancer, then you're hoping that it will develop cancer and you can use that cancerous mouse to try out medicines and see if those medicines help make that cancer go away in the mouse. So a mouse that can get cancer is actually a very, very valuable thing. Now, you'd say, well, I'm pretty sure if I go to the pet store, I can buy a mouse, so shouldn't they be able to buy and sell this mouse? Well, it's complicated because what they were trying to protect, and this was Harvard, the university was trying to protect their intellectual property, not so much of the actual individual mice, but in the genetic code for the mouse, because the genetic code was what it was that made the mouse valuable. It's what made it able to get cancer so often. And they had a patent for this in the United States. But the way that intellectual property works is that it's based on international jurisdictions, right? That's why if you have some countries where they don't really have copyright laws in place, then they can do all kinds of pirating there. There are some places that we've talked about earlier in the year where they've had servers that would run illegal Pirate Bay type servers that would harbor information that would be in breach of copyright laws in various countries. So when Harvard was thinking about getting this mouse genetic code protected in Canada, they needed to get it under the patent laws of Canada, right? This isn't copyright. It's not like they created mice, really. It's more that they've come up with an invention, a mouse invention. But this is kind of a tricky idea, right? Because once you start talking about mice as inventions, like a mouse is a mammal, right? It's adorable. It's got a little face. Some people don't like mice at all, but other people, they're very cute. And once you start trying to patent cute things, that's pretty close to patenting humans. And that's kind of a line in the sand that the Canadian Supreme Court was maybe a little nervous about crossing at the time that this case came to the Canadian Supreme Court. Because it did get all the way to the Canadian Supreme Court after passing through the federal court and the Federal Court of Appeal. And the argument was over whether or not you can get a patent on an invention that happens to be a living thing. And that's what Harvard was trying to do. So the Supreme Court ultimately wrote a decision. It was a very convoluted one that expressed that you can't grant patents on what they called higher life forms because they're composed of something other than matter. Now, something other than matter that's a very vague concept. Was the Supreme Court of Canada saying that mice have souls? It's kind of hard to tell, right? Definitely, they were more worried about when people would start to patent something that would be closer to humans, because then when does a human become a human? The ineffable essence of identity is difficult to nail down. So they decided that, well, wherever the line is, it's somewhere below mice, and you can't patent genetic codes of mice. But if you read through the decision, it's a long one. It's not a particularly entertaining read. It's very confused in trying to draw exactly where this line is, which makes sense because it's a difficult line to draw. But in the end, the Supreme Court's decision was, sorry, Harvard, you can't patent these mice. You can sell mice, but you can't sell the genetic code of mice. The last case we'll look at is also a medical case. But the concerns in this one were different from what was going on with the mouse in Harvard Mouse. This is a case actually from quite some time ago, from ultimately rooted back in 1976, when a guy named Moore went to the University of California in Los Angeles, UCLA, to be treated when he was diagnosed with hairy cell leukemia. And he wasn't feeling well, obviously, so he was looking for medical care. And UCLA was a medical research university, so they were able to give him some care there. Now, what they did with Moore was they were trying to figure out how to treat his hairy cell leukemia. And over the course of it, they ended up removing his spleen because the spleen, I think, had become very inflamed. There was some good reason why they needed to take it away. And he signed a consent form before the surgery, which was necessary. They were really just trying to do good surgery on him here, and so they removed the spleen. But after they had removed the spleen, after he had gone off, they realized that his spleen was actually very valuable because there was something very unusual about it, and that there was a protein that would be produced in the spleen that would help stimulate white blood cells. And white blood cells are the ones that help you fight infection in your body. So the fact that there was some ingredient being produced by this spleen that they had taken away from the guy that was producing this meant that, wow, this was valuable to them. And so they conducted research using what they'd gotten from the spleen, and they found a way to actually start a cell line that was ultimately instrumental in producing a commercially successful treatment. Now, all this was done without Moore knowing about it, right? When he went in, everything was fine. I mean, he wasn't fine. He was suffering from hairy cell leukemia, but everything was on the up and up in terms of them removing his spleen. There wasn't any ulterior motive. However, after this had been done and they started to realize the value of it, the University of California started doing some things that were maybe a little bit sly in terms of not really revealing to Moore what their plans were. For example, he moved out of the state. I think he moved to Oregon later on, and he wanted to try and transfer his medical files so that he could, be followed by another doctor up there. The doctors at UCLA were like, no. Look, we'll pay your airfare. We'll bring you down here. Just please keep coming to us. Keep coming to us. And they kept extracting through legitimate blood tests. They kept extracting material that they knew could be useful to them. And so they weren't quite being forthcoming with him. And I believe in 1983, so 7 years after he first started getting treatment, they had him sign this form, or they tried to get him to sign this form that was trying to, it said something like, I relinquish all rights to any medical products that may be generated using my parts or whatever it is. And he saw this and he thought, this doesn't seem right. I feel like there's something weird going on here. And sort of the court case started from there. Now, the case went on all the way up to the Ninth Circuit Court of Appeals, which is kind of one step below the Supreme Court if you're in California. And at that point, the court was in a difficult situation because, on the one hand, they knew that the University of California had been acting badly to some degree here. They weren't being very forthright with the patient. There were some medical ethics issues, perhaps, in just not being above board. But at the same time, they were very worried, the Court of Appeals. They didn't want to get to a case where people would have a property interest in their body parts. Because when people died, often, there would be organs that would be people would sign organ donor consent forms, and they didn't want the families of these people, coming up and saying, well, we actually, we want to claim the right to the eyes that the corneas that have since been transplanted. We want an injunction to have that guy's corneas removed because they came from our son who was killed in a motorcycle accident. They were very worried about anything that would remotely establish property interest in body parts. So even though Moore was trying, some kind of legitimate grounds to say, like, look, these guys have been stringing me along. They've been using my body parts to generate a commercially successful treatment. They've been making a lot of money off of my body parts. I want to be able to claim some property interest in that. The court said, well, as much as we're annoyed with what the university did here, there's no way that we want to start going down the road of recognizing body parts as something that you can claim as property. And so, unfortunately for Mr. Moore, they did not give him any money for that, as annoyed as they might have been with the university.